71 urgent, 72.
Come. Just keep it there tomorrow. Yes.
Just to recapitulate, no
No need.
need.
We are just only one day away, Mr.
I
Chairman.
know, not. I'm not going to take. I only want to make one point.
I have only one submission in this, Malad. I filed an implementing application for the auto rickshaw unions. Malad.
For the
Auto rickshaw drivers
Okay,
unions.
okay.
Who want to
This-
oppose?
This is this side now.
Yes.
Fortunately, yesterday was more on my side. Now the that side, my lord, is getting populated a little more.
Yes.
Yesterday, my lord, I almost stopped at the point where I said that if the statute is clear and the law has been declared by this court, there can't be a policy contrary to that. And then, my lord, I said that insofar as a rider is or an owner is concerned, he's entitled to register it as a transport vehicle and get a contract carriage permit, both of which can't be denied unless there is a good enough reason which should be contained in the rules, which are made, my lord, by them. Now, if I satisfy all the requirements that are there in the rules for being granted a contract carriage permit, I should be granted it, unless there's some rule which says I should not be granted it. Now, the case of the state can't be that dehors the rules or dehors the act. I will now make a policy, and that policy will say I will not give permission to anybody to use it as a contract carriage. There, my lord, is where we stop. I want to start, my lord, my submission today, pointing out that the right to utilize my vehicle as a taxi or a transport vehicle is a fundamental right. And therefore, I have a fundamental right under Article 19(1)(g), which is recognized in two judgments. I'll place those judgments first before your lordships. Lord Sagir Ahmed and Mithilesh Garg. I'll just pass it on. Lord has the first one, Lord, is a constitution bench judgment on under the old act when they were license Raj, and even then, whether to operate a vehicle as a transport vehicle was a fundamental right was a question. In Sagir Ahmed,
Give it. Yes.
para 12 on the 4th page. Lord, may come to the extract, a few lines before the extract at para 12. Under the Indian Constitution, it starts.
Yes.
My Lord's got Sagir Ahmed. I think my Lord Justice Joshi has Sagir Ahmed. Para 12. 5 lines before the extract.
Yes.
Under the Indian Constitution, the contract carriers as well as the common carriers would occupy the same position so far as the guaranteed right under Article 19(1)(g) is concerned. Both are liable to be controlled by appropriate regulations under Clause 6 of that article. The law on the point as it stands at present has been thus summed by the learned judge. The true position then is that all public streets and roads vest in the state, but the state holds them as trustees on behalf of the public. The members of the public are entitled as beneficiaries to use them as a matter of right, and this right is limited only by the similar rights possessed by every other citizen to use the pathways. The state as trustees on behalf of the public is entitled to impose all such limitations on the character and extent of the user as may be requisite for protecting the rights of the public generally. But subject to such limitations, the right of a citizen to carry on business and transport vehicles on public pathways cannot be denied to him on the ground that the state owns the highways. Well, that argument is not advanced here as yet, because the roads are the state roads. That's the only argument which is not advanced, I must say.
Yes.
Para 13, we are in entire agreement with the statement of law made in these passages. Within the limits imposed by state regulations, any member of the public can ply motor vehicles on a public road to the extent he can carry on the business of transporting passengers with the aid of vehicles. It is to this carrying on of the trade or business that the guarantee in Article 19(1)(g) is attracted, and a citizen can legitimately complain if any legislation takes away or curtails that right any more than that is permissible under Clause 6 of that article. Now, my lord, all reasonable restrictions are contained in the acts and the rules. And the act and the rules prescribe the entirety of what could be done. We have not challenged any of those, nor are we complaining against any of those. Our entire complaint is you are doing something outside it. If the law therefore permits it and therefore enables me, my lord, to exercise freedom of profession or freedom of business, then it is incumbent on the state to take every step to protect that right. The state cannot turn around and do something which will disable that right, which is exactly what's happening today. And that can't be done. Similar, my lord, after the 1988 Act, in the context of motor vehicles, in Mithilesh Garg, I think the other judgment which has been given to your lordship. Para 5, my lord. Para 5. Parliament in its wisdom, I'm sorry, my lord's got. Parliament in its wisdom has completely effaced the above features. The scheme envisaged under 4757 of the old Act has been completely done away with the Act. The right of existing operators to file objections and the provision to impose limit on the number of permits have been taken away. There is no similar provision to that of section 47 and 57 under the Act. Statement of objects and reasons of the Act shows that the purpose of bringing in the Act was to liberalize the grant of permits. Section 71(1) of the Act provides that while considering an application for a stage carriage permit, Regional Transport Authority shall have regard to the objects of the Act. Section 82, which is the harbinger of liberalization, provides that the RTA shall not ordinarily refuse to grant an application for permit of any kind made at any time under the Act, which was a submission I made yesterday. There is no provision under the Act like that of 47(3) of the old Act, and as such, no limit for the grant of permits can be fixed under the Act. There is, however, a provision under 71(3)(a) of the Act, under which a limit can be fixed for the grant of permit in respect to the routes which are within a town having a population of more than 5 lakhs. Then, my lords, may kindly see on 176 near Placetum B.
Yes.
Overcrowded buses, passengers standing in the aisle, persons clinging to bus doors, even sitting on the rooftop are some of the common sights in this country. More often, one finds a bus which has a noisy engine, old upholstery, uncomfortable seats, continuous emission of black smoke from the exhaust pipe. It is therefore necessary that there should be plenty of operators on every route to provide ample choice to the commuter public to board the vehicle of their choice and patronize the operator who is providing the best service. Even otherwise, the liberal policy is likely to help in the elimination of corruption and favoritism in the process of granting permits. Restricted licensing under the old Act led to the concentration of business in the hands of few persons, thereby giving rise to a kind of monopoly, adversely affecting the public interest. The apprehensions of the petitioners that too many operators on a route are likely to affect adversely the interest of weaker section of the profession is without any basis. Transport business is bound to be ironed out ultimately by the rationale of demand and supply. Cost of a vehicle being as it is, the business requires huge investment. Intending operators are likely to be conscious of the economics underlying the profession. Only such number of vehicles would finally remain in operation on a particular route as are economically viable. In any case, the transport system in a state is meant for the benefit and convenience of the public. The policy to grant permits liberally under the Act is directed towards the said goal. And then, Lord, para 9. Article 19(1)(g) of the Constitution of India guarantees to all citizens the right to practice any profession or to carry on any occupation, trade or business subject to reasonable restrictions imposed by the state under Article 19(6). A constitutional bench in Sagir Ahmed, which I read to your lordship, held that the fundamental right under 19(1)(g) entitles any member to the public to carry on the business of transporting passengers with aid of vehicles. I won't read that extract after that. It is thus a guaranteed right to every citizen, whether rich or poor, to take up and carry on, if he so wishes, the motor transport business. It is only the state which can impose reasonable restrictions within the ambit of 19(6). Section 47(3) and 57 of the Act were some of the restrictions which were imposed by the state on the enjoyment of the right under 19(1)(g), so far as the motor transport business was concerned. The said restrictions have been taken away. Provisions of 47(3) and 57 have been repealed from the statute book. The Act provides liberal policy for the grant of permits to those who intend to enter the motor transport business. Provisions of the Act are in conformity with Article 19(1)(g) of the Constitution of India. Petitioners are asking this court to do what the Parliament has undone. When the state has chosen not to impose any restriction under 96 of the Constitution of India in respect to motor transport business and has left the citizens to enjoy their right under Article 19(1)(g), there can be no cause for complaint by the petitioners. Here, my lord, a set of people wanted to stop stage permits from being granted liberally, which is basically concentration of those permits in the hands of some. Supreme Court says, we've opened it up. The state has opened it up in exercise of, or to guarantee that right which every citizen has under Article 19(1)(g), and therefore stage permits can now be given liberally. Today we have a scenario where the state is coming to your lordships and saying that contract carriage permits for motorcycles, which is otherwise allowed under the Act and guaranteed not by an order of this honorable court, will be done away with because we have a policy of not allowing it. Isn't that, in my humble submission, a complete violation of Article 19(1)(g)? And ultimately, my lord, please see the consequence of it. The consequence of it is exactly what the Supreme Court is saying. The consequence of it is to protect the interests of existing players. Autos, we are not saying take away autos. Autos can remain, you can do everything further to improve their business as well. But today you are saying we will not allow someone else to come, though the law permits it. Can that, my lord, in my humble submission, be said to be a restriction which you can impose outside the law itself, simply by virtue of a statement of objections filed in a writ petition? And that becomes the policy of the state. Then, my lord, the second point which I was making yesterday was on the point, my lord, as to whether by virtue of either executive instructions or a policy, unstated as it is in this case, could there be a restriction or limitation placed by policy? If there is a policy, it is an unstated, illusory, imaginary policy, not written anywhere else except the statement of objections and a contention taken. There is no government order, no following of transaction of business rules in order to formulate a policy, because your lordships know, to formulate a policy as well, there has to be application of mind, there has to be an analysis of all facts, and then a policy of the government. Even if all of that had been done and there was a policy placed before the court, the policy could not be contrary to statute. In this case, that policy is illusory. The policy does not exist. Please see, my lord, in this context, a few judgments very quickly I'll show your lordships. The first one is, just keep on it. Yes.
They cannot be, in exercise of an executive power.
Yes.
They can come out with any policy, restricting it, though the field is occupied under the Motor Vehicles Act. How would you answer that? Ultimately, in exercise of the
yes, lord. When an issue is covered by statute, executive instructions cannot supplant it, but they can supplement it. When we say supplement it, supplement, my lord, is to enable it further, not to disable it. Therefore, at least my understanding of the law, my lord, is, and I'll show one or two judgments to your lordships, is that in case your lordships come to a conclusion that the entirety of the law has actually been covered by the Motor Vehicles Act, both with respect to permits and with respect to registration as a transport vehicle, because those are only two things. A transport vehicle with a contract carriage permit is a taxi, because there is no separate definition of a taxi. The second, I have a contract carriage permit, I can use it for hire or reward. I have to get it registered as a transport vehicle. I have to obtain a permit from the Regional Transport Authority as a contract carriage, because it is from one point to the other, and I charge a customer from point to point. Then I'm entitled to use it as a taxi for hire or reward.
But tell us, Mr. Chinnappa, a situation has come where they have actually, though the statute, the provisions of the Motor Vehicles Act, what you have been arguing, but a situation has come where the government has to step in and to state that this type of vehicles I will stop. How would you answer that?
Yes.
That kind of a situation. Otherwise, given the situation it is such a situation where not even one vehicle can be added to the, to the traffic. So such a situation has come. The government said, now I have to come step in. Though the provisions of the statutes are in a particular way, which I can't restrict, but in exercise of my executive powers, now I will do it.
That they can't. That they can't.
Okay.
It can only be by an amendment to the statute. If I may put it, my lord, pithily, the executive power of the state ends when the statute begins. The second the statute begins, then, my lord, there is no power that can be exercised by the state in exercise of 162 power or any other power that the center has to supplant a law or to practically provide an exception to the law. You can only supplement it. And that's the entirety of the power, because the legislature has decided that this is the entire scope of the legislation. And in this scope of legislation, this is what, as a delegate, the state can do. Because now the state's power has been restricted to as a delegate. And it has been told that these are the areas where you can make rules, whether it's a central government or the state government. Now, tomorrow's situation, as your lordships point out, has come, where the vehicle population in the city has become so much that there's no space to have more vehicles. Then, my lord, you must legislate to find a way out of that scenario. Like possibly, my lord, in Singapore, they say you buy a car, you have to ensure one car goes off the road. It could happen in one day, my lord, may come when that has to be done because of the number of cars. But it is essentially a legislative power, because it practically results in some ways of expropriation of a property, which is also a car, and saying you cannot have a car on the road anymore. But also it happens, my lord, when your lordships now know that a certain age is fixed for a car. If they say tomorrow, beyond that age, we will not allow a car to ply, or 15 years or 20 years. No cars will be there. So all the old cars will get removed and new cars will come onto the road. That is one way of fixing it. But their policy today is not that because there are too many vehicles, we want to avoid bike taxis. That is not the stated policy. They said we don't want bike taxis for reasons, my lord, which we don't know, because there is no decision of the government before your lordships, except a statement made in court. That is not policy.
Okay.
Now, my lord, please see this judgment in my humble submission at 2006-9 SEC 1, para 62. This, my lord, as a matter of fact, possibly is the judgment which fits almost best to this case. Para 62 at page 32. This is, of course, higher standards. NCT. From the above decisions in our judgment, the law appears to be very well settled. So far as coordination and determination of standards and institutions for higher educational research, scientific and technical institutions are concerned, subject is exclusively covered by entry 66 list 1 of schedule 7. State has no power to encroach upon the legislative power of parliament. It is only when the subject is covered by entry 25 of list 3 to the constitution that there is a concurrent power of parliament as well as the state legislatures. The appropriate acts can be made by the state legislature, subject to limitations and restrictions under the constitution. I'm sorry. Oh, I'm so sorry.
Nothing between us.
Oh, I see. I thought I was reading with you, Lord.
No, it's all right.
That.
No. Yeah. The moment you say Sandhyanesha, I went to the appearance, that's all.
Oh, I see.
This is in context of NCT.
NCT.
That's right. Yeah, go ahead.
Now, please see para 63, my lord, on this occupied argument. In the instant case, admittedly, Parliament has enacted the 93 Act, which is in force. The preamble of the Act provides for establishment of NCTE with a view to achieving planned and coordinated development of the teacher education system throughout the country. Regulation and proper maintenance of norms and standards in the teacher education system and for matters connected therewith. With a view to achieving that object, NCTE has been established at 4 places by the central government. It is thus clear that the field is fully and completely occupied by an Act of Parliament and covered by entry 66 of list 1 of schedule 7. It is therefore not open to the state legislature to encroach upon the said field. Parliament alone could have exercised the power by making appropriate law. In the circumstances, it is not open to the state government to refuse permission relying on a state act or on policy consideration. Even otherwise, in our opinion, the High Court is fully justified in negating the argument to the state government that permission could be refused by the state government on policy consideration, which is the argument here. As already observed earlier, policy consideration was negative by this court in so-and-so, as well as Jai Kokul Education Trust. Then PC 68. In view of the fact, however, that according to us, the final authority lies with NCT, and we are supported in taking that view by various decisions of this court. NCT cannot be deprived of its authority or power in taking an appropriate decision under the Act, irrespective of absence of no objection certificate by the state government or union territory. Absence or non-production of NOC by the institution therefore was immaterial and irrelevant so far as the power of NCT is concerned. Here, my lord, what happened was, I don't know if your lordships are aware of this.
Go ahead.
A case where
No,
your lordship said
go
it.
ahead. No, it's all right, Mr. Don't go
Oh, I
into
see.
it.
Okay.
Go ahead.
That-
It was basically
It'll be-
interplay between the NCT regulations and the state government policy.
Correct.
Not to allow a teacher education institution to come in.
Exactly.
Then what the Supreme Court said, when the power lies, the field is occupied by the NCT regulations. You have no authority to say that I will not allow.
Correct.
That will have.
And my lord, in this case, I'm sorry. Overriding effect, which is what I'm also saying, which is, my lord, a classic scenario where, in this case, without the permission of the state government, they set up institutions. And they said, we have set up institutions on the basis of the consent given to us by NCT. Quite something like ours, where on the basis of the law that exists, we are all saying we are entitled to apply as motorcycle taxis. And then Supreme Court said we can't interfere and now say stop. Because you've already invested, you've spent money, and you set up these institutions on the basis of the law that governs, not on the basis of a policy that the state then decides to say you need an NOC from us before you establish a college here. Therefore, what I'm only pointing out is this somehow matches in almost on all fours, if I may say so, with what the state government is saying here. On the first date, when your lordship asked them the question, can you register a vehicle as a transport vehicle and grant a contract carriage permit? They said yes, but we don't want bike taxis. But there's nothing else but that which is a bike taxi. How then by policy are you saying I will not allow a registration of a vehicle as a transport vehicle because your RTA has to do it? I will not grant a contract carriage permit though your RTA has to do it. And the law in the section 80 is ordinarily you can't refuse. And there are considerations as to who can apply. If I satisfy those requirements, I'm entitled to that permit. The state can't refuse the permit to me unless the rules prescribe it. But a policy says I will not allow you to even apply. I will not allow you to even come and make an application. Even if you make an application, I will not even look at it. I will not receive the fee. And I will therefore not register your vehicle as transport vehicle or give you a contract carriage permit. That is a policy, my lord, which is contrary to the law. And that policy can't dictate as to the manner in which the law operates. The field, therefore, is occupied and nobody else, my lord, two delegates, either the central government or the state government, cannot act contrary to the act of legislature. If you do, you violate my right under Article 19(1)(g), because I have a right to operate my vehicle as a transport vehicle. And that right, in my humble submission, is subject only to the restriction under 19(6), which is by law prescribed. Where, my lord, I ask myself, is a policy coming in beyond the law? That can't be done. Of course, your lordships. No, you found your lordship's appearance.
Yes. The moment you said Sandhyaneshwar, see, this has been followed later.
Yes,
in
yes,
many
followed
judgments.
several times.
And this became a law. Law is obviously the regulations were such. NCT, it's only the interpreting the law. The Supreme Court has said
It's true. Only 78 then. Lordship may only see 78. I'm sorry, 77. Learned counsel for respondents are also right in relying upon the provisions of 19 and 21A of the Constitution. Under Clause G of Article 19(1), all citizens have the right to practice any profession or to carry on any occupation, trade, or business, unless they are restrained by imposing reasonable restrictions under 19(6). In the instant case, applications had been made by colleges to NCTE under the 93 Act, and after complying with the provisions of the Act, permission was granted by NCTE. The state thereafter could not have interfered with the said decision. It is clear Article 21A would cover primary as well as secondary education, and the petitioners could claim benefit of Part 3 of the Constitution as well. The respondents have stated that they have spent huge amount and incurred substantial expenditure on infrastructure, library, staff, and after satisfying themselves about the necessary requirements of law, permission had been granted by NCTE. If the said action is set aside on the basis of the decision of the state government, irreparable loss will be caused to them. Since in our view the order passed, an action taken by NCTE cannot be termed illegal or unlawful, and the state government could not have passed the impugned order, refusing permission on the ground of the so-called policy of not allowing new B.Ed colleges to be opened. It is not necessary for us to delve into the said contention.
Yes.
Then, Lord, one more judgment on this issue. A.B. Krishna. This note was in Article 309 and rules made under 309, and whether rules can be made under 309 when it is already occupied by a state legislation. Could there be even rules made in exercise of the power of Article 309 when there's already legislation in terms of the Karnataka Civil Services Act? That note was answered saying you can't. Therefore, even the constitutional power to make rules exists only if there's no legislation operating in the field. Para 8 and 9. Fire services under the state government were created and established under the Fire Force Act 1964 made by the state legislature. It was an exercise of the power conferred under Section 39 of the Act that the state government made service rules regulating the conditions of the fire services. Since fire services had been specifically established under an act of legislature and the government in pursuance of the power conferred upon it under that act had already made service rules, any amendment in the Karnataka Civil Services General Recruitment Rules would not affect the special provisions validly made for fire services. As a matter of fact, under the scheme of Article 309 of the Constitution, once a legislature intervenes to enact a law regulating the conditions of service, the power of the executive, including the president or the governor, as the case may be, is totally displaced on the principle of doctrine of occupied field. If, however, any matter is not touched by that enactment, it will be competent for the executive to either issue executive instructions or to make a rule under Article 309 in respect to that matter. It is no doubt true the rule-making authority under 309 of the Constitution and Section 39 of the Act is the same, namely the government, to be precise, the governor under 309 and the government under 39, but the two jurisdictions are different. As has been seen above, power under 309 cannot be exercised by the governor if the legislature has already made a law and the field is occupied. In that situation, rules can be made under the law made by the legislature and not under Article 309. It has also to be noticed that rules made in exercise of the rule-making power given under an act constitute delegated or subordinate legislation, but the rules under 309 cannot be treated to fall in that category, and therefore on the principle of occupied field, the rules under Article 309 cannot supersede the rules made by the legislature. Next. Now, my lord, when policy decision is contrary to law, which is the best? This is also NCT, I think, on NCT itself, but a more recent judgment, not in 23. May I request Manoj to kindly come to para 70. Para 71. We have absolutely no doubt in our minds that policy decisions of the government should normally not be interfered with by a constitutional court in exercise of its power of judicial review. At the same time, if the policy decision itself is contrary to the law and is arbitrary and irrational, powers of judicial review must be exercised. A policy decision which is totally arbitrary, contrary to the law, or a decision which has been taken without proper application of mind or in total disregard of relevant factors is liable to be interfered with, as that also is the mandate of the law and the Constitution. This aspect has been reiterated by this court time and again. Judicial review becomes necessary when there is an illegality, irrationality, or procedural impropriety. These principles were highlighted by Lord Diplock. I won't trouble your lordships with this. Then, Lord, para 77. As in our case, which is almost identical. In the present case, and in the larger context of the matter, we cannot even see this as a policy decision because there is no policy decision in this case except a statement. But without getting into this argument, even presuming for the sake of argument that the decision taken at the government level to include B.Ed as a qualification for teachers at a primary level is a policy decision, we must say that this decision is not correct as it is contrary to the purpose of the Act. In fact, it goes against the letter and spirit of the fundamental right enshrined in the Constitution in Article 21A. It is against the specific mandate of the Act, which calls for free, compulsory, and meaningful primary education to students.
But does it say, the judgment say it's when the field is occupied by the NCT Act and the regulations? this policy decision cannot stand.
That's,
Does it say so?
it does. As a matter of fact, I'm sorry.
Which paragraph?
Yes. It's more, please see 69. Because here the question was, what should NCTE do? Especially when the central government is to issue an instruction in exercise of a statutory right. Because under the Act, the central government can issue instructions. Para 69. NCTE is bound to follow the 69, page 359. NCTE is bound to follow the directions of the central government in this regard, and the direction in the present case was to include B.Ed as a qualification for teachers in primary school, which has been done by NCTE through a notification dated so and so, or the submission of learned counsel appellants as well as that of the learned ASG on behalf of the Union of India. Moreover, as per subsection 2 of section 29, the decision of the central government as to what constitutes a policy decision will ultimately matter is also the argument. This is the argument. This is the instruction there. Introduction of B.Ed as a qualification by NCTE on the direction of central government is a policy decision of the government as has been submitted before this court and is also evident from the sequence of events, minutes of various meetings, and the order passed in this regard. Section 29 of the NCTE Act, which mandates that NCTE must follow the direction of central government in discharging of its functions. It is a policy decision which binds NCTE. Then Lord, he says as to how the policy decision has to be taken.
Now read the last line of paragraph 71.
Yes. At the same time, if the policy decision itself is contrary to the law and is arbitrary and irrational, powers of judicial review must be extended. At least in this case, there was some order, there were some minutes of meeting. All of that was placed before the court saying this constitutes the policy decision. We don't have that decision here. Other than the decision saying we will not have bike taxis, e-bike taxis, which is a withdrawal of a notification, that itself has been construed, I don't know if they are trying to construe it, as a policy decision not to have bike taxis at all. If that is, then there is really no application of mine, except a withdrawal, simpliciter, of a e-bike taxi notification which had been issued. And the reliance, my lord, before the court, and what the learned single judge has also examined, is only that report of that committee. And there's nothing to show it has been accepted. Because they've acted 2 years later contrary to the report. 2019 was the report, 2021 is the e-bike taxi policy. How did you come with an e-bike taxi policy in 2 years? When the report said don't do bike taxis, and we're not convinced that bike taxis are required, while the entire city today is saying we want bike taxis.
Yes.
Therefore, even if there's a policy, it can't be arbitrary, irrational, and contrary to the law. And in my respectful submission, a policy which says I will act exactly contrary to what the Motor Vehicles Act says is contrary to law.
Okay.
Then, my lord, there are a few judgments. I'll just. Where's the constitutional judgment? How do the executive instructions contrary to? Be presidential for. That okay. This is an important one.
Yes.
Lord, in Bishambar Dayal, on considering section 73 and Article 173 and 162 of the Constitution, this is what the Supreme Court has said. Because this has to be an exercise of power under 162 for the state.
That's right.
Somewhere in the middle, in Ram Javaiya Kapoor was the state of Punjab, Mukherjee CJ, dealt with the scope of
which page is that?
56, page 56, para 20. 10th. It says just above in Ram Javaiya Kapoor, in the middle. The executive power of a modern state is not capable of any precise definition. In Ram Javaiya Kapoor, a state of Punjab, Mukherjee CJ dealt with the scope of 73 and 162. The learned Chief Justice observed, neither of the two articles contains any definition as to what the executive function is or gives an exhaustive enumeration of the activities which would legitimately come within its scope. It was observed, ordinarily, the executive power connotes the residue of governmental function that remain after legislative and judicial functions are taken away. It is neither necessary nor possible to give an exhaustive enumeration of the kinds and categories of executive function which may comprise both the formulation of the policy as well as execution. In other words, the state in exercise of its executive power is charged with the duty and the responsibility of carrying on the general administration of the state. So long as the state government does not go against the provisions of the constitution or any law, the width and amplitude of its executive power cannot be circumscribed. Then, my Lord, 27. The quintessence of our constitution, 27. The quintessence of our constitution is the rule of law. State or its executive officers cannot interfere with the rights of others unless they can point to some specific rule of law which authorizes their acts. In State of MP versus Thakur, the court repelled the contention that by virtue of Article 162, the state or its officers may, in the exercise of executive authority, without any legislation in support thereof, infringe the rights of citizens merely because the legislature of the state has power to legislate in regard to the subject on which the executive order is issued. It is observed, every act done by the government or its officers must, if it is to operate to the prejudice of any person, be supported by some legislative authority. The same principle was reiterated by the court in Savant Singh. And then, Lord, on the specific issue arising there, the court examined it.
Yes.
Para 19 in GC Dal, court of, madam. This is on what can be done, Lord, when there is a statute. Page 174. 174. This also seems to indicate as to how wrong the state is in our case. The second ground on which the full bench has sought to invoke the instructions is also not correct. Executive instructions can supplement a statute or cover areas to which the statute does not extend, but they cannot run contrary to statutory provisions or whittle down their effect. The full bench seems to think that unless the instructions are brought in, the notifications would have been in danger of abuse for want of proper guidelines as to the grant of exemption certificates. It is suggested that the notification contemplates rules to be issued for the purpose, and since no rules had been issued, Director of Industries were left with no parameters for the issue of exemption certificate and might act capriciously or arbitrarily in granting or refusing certificates. The instructions, it is said, have been issued to fill in this lacuna and are hence valid. There are two misconceptions in this line of reasoning. The first is that, though the last few words in column 3 of the notification are capable of a wider meaning, it will appear that these words govern only the immediate preceding words. Rules envisaged are not in relation to the grant of exemption certificate and conditions therefore, but in respect to the circumstances in which the SSCs can exercise the option between exemption and deferment of sales tax. This view derives support from the instructions of 83. As pointed out earlier, instructions first set out the scope of the various notifications as granting exemption from sales tax. The instructions thereafter proceed to say, and so on. Then, Lord, on page 176, on this instructions, the court then answers it, between placetum C and D. Only instructions were issued, it says. Only instructions were issued. These instructions say that even an SSE who fulfills all the requirements of the notification will not be eligible for exemption unless he fulfills one more condition outside the notification. They travel beyond and counter to the notification. They restrict the scope of exemption under the notification. They deny exemption to a person who qualifies for it under the statutory notification. Indeed, there is force in the contention that if the statutory notification is construed as permitting the state by rules or executive instruction to prescribe other conditions for exemption, whether new or based on past practice, it is liable to be struck down on the ground of impermissible delegation of legislative power to the executive. This certainly they cannot do. I'll put the others now. There are a number of them, and I'll put the others on the similar proposition in a note for your lordships. Now, my lord, if I may respectfully put together these 2 points, policy can't be contrary to the statute, and there cannot be policy outside the statute because your entire power is now encapsulated in the statute. And therefore, whatever power that you wish to exercise, you must exercise by making rules. And the rules have already been made, and they exist today. The motor vehicle rules have been made by Karnataka, and there's central motor vehicle rules as well. Central motor vehicle rules deal with certain areas, state motor vehicle rules deal with certain areas. In each of these rules, the entirety of what has to be done and how an application for permission has to be dealt with is examined. Once all that is done, those, my lord, are, if at all, reasonable restrictions under Article 19(1)(g). And there cannot be anything over and beyond it. Today, by virtue of an action taken by the state, you have disabled a citizen from exercising that right. My right to register my vehicle as a transport vehicle in my respectful submission is a right emanating from Article 19. My right for a contract carriage is a right that emanates from Article 19(1)(g). And both of them are protected by statute, and which is why Supreme Court said that right of every citizen to ask for a stage carriage permit is protected by statute. And that is a right which I have today. If I have that right and you disable my exercise of that right, then you cannot complain if there is any violation. You have brought about the situation today where, my lord, people are operating bike taxis because you refuse to give me permission. I have applied. I have written, my lord, there are documents on record to show that I wrote to the government saying I want to convert my vehicle from a non-transport vehicle to a transport vehicle and apply for a contract carriage permit because the judgment of the division bench authorizes me to do so. And the law says so. They don't allow it. They come to your lordships and say we will not allow it. If they take such a position, they have disabled my right under Article 19(1)(g). And today I ask myself, is it open for the state then to complain that there is a violation by somebody of what I disabled? If you have created a scenario where you have disabled the right of a citizen, it is not open in my respectful submission for the same state to then complain that there is violation. You created that impossibility. And Lord, what in a scenario of impossibility should be done has been considered, Lord, by a few judgments. I want to place those. In re-presidential poll, this is a 7-judge bench judgment examining this contention of what happens in the context of impossibility. Para 15 at page 49. Para 15 minutes. The impossibility, page 49. The impossibility of the completion of the election to fill the vacancy in the office of the president before the expiration of the term of office in the case of death of a candidate, as may appear from section 7 of the 1952 Act, does not rob Article 62(1) of its mandatory character. The maxim of law impotentia excusat legem is intimately connected with another maxim of law, lex not cogit ad impossibilia. Impotentia excusat legem is that when there is a necessity or invincible disability to perform the mandatory part of the law that impotentia excuses. The law does not compel one to do that which cannot possibly perform. Where the law creates a duty or charge and the party is disabled to perform it without any default in him and has no remedy over it, then the law will in general excuse him. Therefore, when it appears that the performance of the formalities prescribed by a statute has been rendered impossible by circumstances over which the persons interested had no control, like an act of God, or if I may say so, an act of state in this case, the circumstances will be taken as a valid excuse. Where the act of God prevents the compliance with the words of a statute, the statutory provision is not denuded of its mandatory character because of supervening impossibility caused by the act of God. This, my lord, has been fully examined in a more recent judgment in Arjun Pandit Rao. Madam, in the context of 65B of the Evidence Act, that is of obtaining secondary evidence and consequence of not being able to get the certificate under 65B as to whether evidence can be eschewed thereby in a criminal proceeding, of course. But these two principles have been analyzed to say what steps have to be taken. And if it becomes impossible, notwithstanding those steps being taken, then how the law must view it. Para 47, my lords. At page 46. How a caveat must be entered here. The facts of the present case show that despite all efforts made by the respondents, both through High Court and otherwise to get the requisite certificate under section 65B of the Evidence Act from the authorities concerned, yet the authorities concerned willfully refused on some pretext or the other to give such certificate. In a fact circumstance where the requisite certificate has been applied for from the personal authority concerned, and the personal authority either refuses to give such certificate or does not reply to such demand, party asking for such certificate can apply to the court for its production under provisions aforementioned in the Evidence Act. Once such application is made to the court, and the court then orders or directs that the requisite certificate be produced by a person to whom it sends a summons to produce a certificate, the party asking for the certificate has done all that he can possibly do to obtain the certificate. Two Latin maxims become important at this stage. The first is lex non cogit ad impossibilia, that is, the law does not demand the impossible. Impotentia excusat legem, that is, when there is a disability that makes it impossible to obey the law, the alleged disobedience of the law is excused. This was well put in presidential poll in re as follows, which I just read to my lords. I won't trouble your lordships again with that, but please come after the extract of the paragraphs on page 47. It is important to note that the provisions in presidential poll in re was also mandatory, which could not be satisfied owing to an act of God in the facts of that case. These maxims have been applied by this court in different situations in other election cases. These Latin maxims have also been applied in several other contexts by the court. In Cochin State Power versus State of Kerala, a question arose as to the exercise of an option of purchasing undertaking by the State Electricity Board under section 6(4) of the Electricity Act. The provision period then, of course, is on that particular situation where they applied the principle of lex non cogit ad impossibilia. So, oh, I'm sorry, para 51, Lordship, may kindly see para 51. At page 50, para 51. On an application of the aforesaid maxims to the present case, it is clear that though section 65B4 is mandatory, yet on the facts of this case, respondents having done everything possible to obtain the necessary certificate, which was to be given by a third party over whom the respondents had no control, must be relieved of the mandatory obligation contained in the subsection. Now, my lords, I ask for a transport registration. I ask for contract carriage permit. This honorable court not said, declared the law that I am entitled to it. I went to the state and made requests. State refused by simply not considering And when we filed a writ petition to give effect to it, they took a position before the court that we will not give it. Notwithstanding the requirement of the law that they must give it, and permissions must be granted as held by the Supreme Court as being a fundamental right. They disabled it. Having disabled my right to obtain it, when I'm willing and ready to take it, is it open for the state to then complain? How are you then proceeding to use your taxi as a bike taxi? But you did not allow me to do it. You created an impossibility of a scenario. Having created that impossibility, you are now complaining that I'm using my bike as a bike taxi. And then you say you can't even aggregate it. Notwithstanding the policy, which I'll just show you, Lordships, and that is how I'll ultimately sum up, because I'm sure the aggregators will have many more things to say. But in my humble submission, the aggregator rules permit of it. And if that permits of it, it is not open for you to then say an aggregator also cannot be done, or an aggregation of these bike taxis cannot be done. Creating a scenario of this kind by virtue of an act which was entirely within your control and completely beyond my control has created this scenario. You are duty bound to give me registration and permit. If I had both, there was no disability in law which could prevent me from using my vehicle as a bike taxi. When you prevented it, it was that day, my lord, when you created the impossibility which you declared in court as a stand of the state. And that stand of the state is my respectful submission is contrary to the Motor Vehicles Act, is contrary to the judgment of the division bench, is contrary to the judgment of the Supreme Court saying you're bound to grant permits, and in violation of my right under Article 19(1)(g). Now, in this context, finally, my lord, can I request your lordships to kindly see the aggregator rules for a minute? And that's where we had filed it along with a memo yesterday. Yes, yesterday's memo. Yesterday we filed it with the communication. Page 64. My lords have it.
Which clause is this?
Yes, ma'am. If my lord kindly comes to the definition.
We have in the motor vehicle rules.
Oh, yes. No. Your lords have the aggregator rules?
Yes. This car on-demand transport.
Yes. That's the same. Yes.
2016.
Yes, ma'am. Same. That, of course, is subject matter of a challenge. Portions of it were quashed. It is pending before a division bench of this honorable court, where an interim order has been granted, restraining the state from taking any precipitative action against any party. So that order still continues insofar as aggregators are concerned. In this context, now please see the definition of an aggregator in 2.2. 2.2 is aggregator. Aggregator means a person who is an aggregator or operator or an intermediary or marketplace who canvasses, solicits or facilitates passengers for travel by a taxi and who connects the passenger or intending passenger to a driver of a taxi through phone calls, internet, web-based services, GPS, GPRS-based services, whether or not any fare, fee, commission, brokerage or other charges are collected for providing such services. Then please see the definition of taxi, my lord. What is a taxi? 2 subsection 7. Taxi means a motor cab having a seating capacity not exceeding 6 passengers, excluding the driver, with public service permit on contract. The second lot, they have defined the taxi as a motor cab. Your lordship recollect the definition of motor cab. It's a vehicle used for hire which carries up to 6 passengers. Once this rule is already in place, which permits aggregation of taxis, which are motor cabs, you have covered this field as well by virtue of rules, by defining it as a taxi as a motor cab. And adding the words not an extra, it's really a surplusage in some sense, because motor cab is already defined in the Motor Vehicles Act as a vehicle which carries up to 6 passengers. Having defined a taxi and saying it's a motor cab, these rules cover even 3-wheelers, 4-wheelers and 2-wheelers. And 2-wheelers can have a passenger as a transport vehicle. Once, in my humble submission, you have made rules which occupy the field, again, this is yet another instance of you defeating it by saying this rule also does not apply to 2-wheelers. By definition, a taxi is a motor cab.
Yes.
Therefore, my lord, my respectful submission is, whichever bit that the state has raised, insofar as its defense to motorcycle taxis are concerned, first, my right to registration and permit both are guaranteed by law. And if you have created a scenario where it has become impossible for me to perform and get the permit or the registration, it is not open for you to complain that a bike taxi has today been utilized as a transport or a motorcycle has been used as a taxi. And in my respectful submission, subject to what the aggregators may say, by creating this definition of motor cab in the aggregator rules and saying that this is a motor cab and creating rules for that, if you want to make more rules, you can, but you cannot divest a power which or the right which already exists under the rules by saying this may be insufficient. Now the argument, this is not sufficient for motorcycles. Well, that really is your domain. You have to then take into consideration that, make rules. But the rules are only enabling. They only supplement. They don't supplant. You can't really take away the right and say, I'm taking it away completely. Then you have to take away the entire rules itself.
Is it your case? You are covered under this?
Yes, ma'am. My case is aggregators are covered under these rules. And therefore, when I subscribe to an aggregator and say that I want my bike to be shown in their platform as available to the general public, I'm not committing anything wrong. I'm doing exactly what the law prescribes. Now, if you want to add more protection, if the state wants to add more protection with respect to motorcycles, you're entitled to do it.
Without being governed by these rules, he can still ply it a motorbike as a taxi?
Yes, yes. If I'm not, which is why I respectfully submitted, there are two parts to it. These are aggregator rules. These are rules made to aggregators to govern them. My right to operate as a taxi requires only two things: registration as a transport vehicle and a contract carriage permit. With that, I can operate. Whatever conditions you have and which you have prescribed under the rules, you can add as a permit condition to the contract carriage, and I become a bike taxi. A aggregator does nothing more than aggregate these taxis and offer it as one package to the consumer. Therefore, I ask myself, what was wrong in what has been done if the doctrine of impossibility is adopted? In my respectful submission, you brought it on yourself. If the state has brought it on itself by creating this situation, notwithstanding an order of the division bench, it cannot be seen to complain that a bike taxi is causing any difficulty in the state of Karnataka. And finally, my lord, I don't think anyone can dispute that today, in 2019, when bike taxis were not even there, someone said we don't want bike taxis. Or a committee said we don't even want bike taxis. In 2024, you say you've taken a call on this by eliminating e-bike taxi scheme. I can only think of congestion, cost, convenience. The 3 C's. Congestion, cost, and convenience. These ultimately are the hallmark of any growing city. There may be population, and the reason why we have more traffic in our city today is because people from all over are coming to our state and staying here. And that's the greatness of our state, because they come and they want to stay in our state. And if population increases and there are more vehicles, we have to provide for it, because there is an indication of growth of economy. You cannot turn around and say that I will now retard economy because I believe, without any basis whatsoever, nothing has been indicated to the court as if some major study has been conducted to find out the merits or demerits of e-bike taxis or bike taxis. None of that done. Simplest a policy declaration in a court of law, not outside, that we will not have bike taxis. Can that ever be sustained? And the order on the basis simply of a statement of that kind made before the court, in my humble submission, should result in this order of the learned single judge also being set aside. I'm very grateful to them.
Before the aggregators start, since I am canvassing identical issue, because I am for the Bike Drivers Association. Mr. Chinappa was arguing for 2 individuals, because I am arguing for 5,000 members who either are, they're all drivers, they may be owners of the bikes, or they may have. Because I would not supplant, I will only supplement. It should not take me more than 20-25 minutes.
And my lords, in the previous petition, I am appearing for one of the impleading applicants on this side. So whenever my lords feel that whether the impleading applicant should be. My lords, wow, this IA number 5 is for a commuter, for a woman commuter. IA number 5.
Main appellants have to argue.
So just to simplify for your lordship, there are three kind of people here on this side. One is lords the bike.
We want a continuity in the sense.
That's right. That's right.
Since that was part of the field.
Gotcha.
So we complete this and then start with yours, or how we go?
Look, may I suggest, subject to what my learned friends have to say, because my case is identical to what Mr. Chinnappa has said, and therefore I will only take 20-25 minutes more to supplement what he has stated, because I am also for the drivers, I am not for the aggregators. So therefore, if
In that sense, there is a commonality.
yes, so there would be continuity in what has already been placed for your lordships. I will only supplement with certain aspects which I would like to highlight. That's what. Therefore, because I see if I can.
Then you completely.
Very good. Great. Because as I started by saying, these are three kind of entities on this side. One being the bike taxi driver, other being the commuter, the third being the aggregator. On the other side, Lordship has seen the state and now the auto union, which makes it clear, my lords, why all of this is causing trouble to the state. My lords, to begin with, may I say, my lords, the state's case is absolutely in vacuum. There is no policy, there is no regulation, there is no executive order before your lordships. If there was a policy that was notified, if there was an executive order that was notified, that would have been tested in a writ petition. We would have come before your lordship. Your lordships would have tested whether that executive order or that policy can be sustained or not. So therefore, lords, while Mr. Chinnappa has shown to your lordships that it could not be in contravention of what the statute provides, my respectful submission is it's actually in complete vacuum. There is no such policy that exists on ground. There's nothing that has been notified. In fact, to the extent that I had in fact mentioned yesterday, that the so-called policy which the state is relying on before the court of law, and in fact the single judge relies on the policy, is based on an expert report which confines the study only to Bangalore, whereas the question before your lordship pertains to the whole state. That itself shows, lords, that how half-heartedly all of this is being done by the state. Now, lords, I'll start by taking your lordship to Rule 58 and 59 of the Karnataka Motor Vehicles Rules 1989. I'll just make, lords, very basic elementary arguments to show, lords, that in fact state has no case. The lordship has seen the Central Act already.
Yes.
Lordship has Rule 58, lords.
Yes.
Disposal of application for contract carriage, goods carriage, and private service vehicle permits. When an application for contract carriage permit or a goods carriage permit or a private service vehicle permit is received by the Secretary of the Regional Transport Authority, he shall examine whether the powers to deal therewith has been delegated to any other officer under Rule 55 and forward the same to him for disposal. In case where the application referred to in the preceding sub-rule is required to be considered by the Regional Transport Authority, the Secretary shall scrutinize whether the application is in order and call for such further particulars, make such inquiries he may consider necessary, and shall, subject to any general directions of the RTO, decide whether the application be disposed of by circulation procedure or at the meeting of the RTO. Normally, the application should be disposed of within 1 month of the receipt of thereof. 59. Refusal to accept application for permits. Where the state government by notification in official gazette has directed the transport authorities to limit the number of stage carriages generally or of any specified type under Rule 3 of Section 71 or subsection 3 of 74, the number of vehicles of any class for which permits may be granted in any specified route has actually granted permits equal to the maximum number of vehicles of any class in such area, or as the case may be on such route, the RTO shall notify this fact on the notice board of its office and may decline to receive any further applications for permit in respect of class of vehicle in the area or on the route aforesaid. So, Milos, this is only in addition to what the Central Act says, and your Lordship had posed that query yesterday. There cannot be any action of the state which is in contravention to its own rules, 58 and 59. Now, Milos, will see what is the chronology that we are dealing with. Milos, we have an expert committee report that comes in 2019. Then, Milos, in 2020, there were motor vehicle aggregator guidelines which continued, which are still holding the ground. In 21, there was a writ petition, wherein the division bench had directed the motor taxis and the permissibility, the legal permissibility of motor taxis to ply on the roads of Karnataka was examined, and it was directed that state should consider the applications and the permits should be granted. Now, Lordship would see thereafter comes the 14/7/2021 e-bike policy. For a moment, Milords, the cost of repeating some part with Mr. Chinnappa has already dealt with. I'll draw your Lordship's attention to the e-bike policy, only a couple of paragraphs that I want to read out, so that Milords, the whole notion about the issues that have been highlighted in that so-called 2019 study are debunked. Milords may have this. Milords is on page 267 of item number 74. Item 74, Milords. Page 267. Lordship has that. Page 267. Since Lordship has already read what the expert committee had said, because I am only showing the stark contradiction that comes in by the state 2 years thereafter in this policy. Lordship will have, Milords, the first paragraph. I am reading from the 5th line. On one hand, Lordship has that? 7th line, sorry. On one hand, there is phenomenal progress in public transport facilities as well as massive entry of aggregators in the system. On the other hand, cities are still grappling with the issues of massive traffic jams. It is happening due to large number of middle class people still using private vehicles for movement. The gap in the market for the first mile and last mile connectivity is working as the main bottleneck in further use of public transport. There is an urgent need for putting up a system which can provide affordable first and last mile connectivity. And whereas bike taxi is one of the options available, and many states have already started it in one form or the other, bike taxi will promote urban mobility and will act as a first and last mile connectivity solution for citizens, which in turn assist people to access public transport, and especially for accessing metro services. It will also create a flexible entrepreneurship opportunities. The Government of India in the last few years have come up with many policy frameworks amendments in the MV Act with the aim to enable states in introducing bike taxi in urban areas with certain restriction to be decided by the states. Now, Milords, may skip to the next paragraph where Milords, the sections have been discussed. I do not wish to trouble your Lordship has seen. Milords, the Motor Vehicle Act provides for it. That is repeated here. And then Lordship may come to the next page. Second paragraph on the top. Whereas the aim of providing the first and last mile connectivity for public transport and to generate self-employment opportunity, the Government of Karnataka in public interest hereby makes the following scheme regulating electric bike taxi and matters connected therewith. And then Lordship will see Milords, subclause 6 of title extent commencement. It shall apply to an individual who himself is engaged in business of providing his own electric motorcycle or electric bike to persons or passenger desiring to hire same for undertaking a journey. So, Milords, the bike taxi, e-bike taxi rules as they are called, completely, my lords, debunks the reliance on that so-called study and the expert report which came in 2019 when the state itself in 21, when it comes out with this policy, discusses the requirement for bike taxis, especially for last mile connectivity, especially for generating self-employment or the other benefits that will emerge out of this. So, my lords, the argument that the 2009 study holds the ground and should be taken as a policy decision, to my mind, my lords, is an afterthought, my lords, and should not, my lords, be sustained. Now, my lords, I will draw your lordship's attention to the impugned judgment for a minute. Lordship may come to, in my petition, it starts on page 35, because I'll straight away, because internal page 55, I'm troubling your lordship with internally page 55, where the single judge has dealt with in 13.7 with respect to this withdrawal of this policy. Just one paragraph I'll read out. The state government in exercise of its power under so and so has notified Karnataka electric bike taxi scheme enabling business in e-bike taxis. I'm sorry. Lordship has that? 54. Yes. Starting at page 54. Under a license subject to certain terms and conditions. In fact, most of the petitioners have projected their grievance contending that state government is discriminating in permitting e-bikes to be used as taxis. Such opportunities denied to the owners of motorcycles with internal combustion engine. However, the state government by its notification on so and so. So ultimately it was withdrawn after 3 years in 24. This notification for reasons such as, now let's look at the reasons. The scheme does not extend protection to women riders. There is continuous confrontation between auto rickshaw, maxi cabs and taxi association leading to law and order situation. Because this is something that the state should be concerned about and should take remedial measures. Can these reasons become the basis of denying me of my fundamental rights? Because I recall, lordship, well aware of, while it is in context of film industry, Prakash Jha versus state of Uttar Pradesh. There was a movie Arakshan which was to be released. State of UP said, we have to ban this movie because we anticipate a huge law and order crisis if this movie is released. The Supreme Court said that that's your problem. You have to manage the law and order. You can't impeach on somebody's fundamental right of freedom of speech and expression by saying that I anticipate law and order problem. So this appears to be the real reason before your lordship, because the auto rickshaw union is also here, that this is more of a political issue than of a real issue before your lordship. Now, I had posed a question yesterday. That context, I would like to place two rules pertaining to bike taxis. One, which state of Punjab is following. Other is the Union Territory of Chandigarh is following. Because there was a blanket statement that had come from state that no state across the country has any rules with respect to individual bike drivers. So yes, my lords. In fact, what I have placed, yes, both in Chandigarh as well as the state, my lords, separate of the UT. Yes, and therefore, my lords, while there is proximity between Chandigarh and Punjab, these two are absolutely distinct in terms of. How many bikes have been registered? That data, I may not have today, but I'll come back to your lordship on that. Lordship would see. First is the Government of Punjab Department of Transport order of 2017, where the application fee, permit fee, etc. is discussed. Then lordship will see on the next page 9D, which is motorcycle with gear, plied as a contract carriage. The motor vehicle tax is 250 rupees. Then lordship will see the next page. It still continues to be the state of Punjab, as we have not moved to Chandigarh, lords. Lordship will see, this is to all secretaries, RTOs of the state by the government of Punjab, contract carriage permit to motorcycle taxis as passenger carriages. Now, lordship will see plus 2(1)
The word contract carriage shall be prominently written on the vehicle. So they have now put out a scheme how it should be. The vehicle shall be fitted with a yellow plate for the purpose of identification, police verification of the driver at the place of residence for the last 6 months. The vehicle shall carry a first aid box, etc. I'm so sorry, Mullahs, I should have started by reading two. At present, contract carriage permits in the state are limited to 3-wheelers, passenger auto rickshaws, motor cabs, and air-conditioned buses having seating capacity of 16 or more. The above embargo violated the fundamental rights. Lordship, I'm on the same page. I'm so sorry. I skipped para 2. Fundamental rights of the citizen to obtain contract carriage permits for other passenger carriages like 2-wheelers, non-AC omnibuses, AC omnibuses with seating capacity below 16. Besides denying passenger transport services to the travelling public. It is therefore decided with the approval of the state government, the contract carriage permits may be granted to any passenger carriage subject to fulfillment of these conditions. Because then I was reading out the conditions to your Lordship. The next page, Lordship. No, Milords. So, Milords, as I understand and subject to correction by the learned counsels who will appear for the aggregator, the bike taxi is really a concept that has emerged in last 10-15 years. Because prior to that, before the regime of Ola, Uber, Rapido, etc., even for us, Milords, the taxis were from the taxi stands. There were no apps. Now, Milords, in my understanding, Milords, largely is
But there is no stipulation in the possibility.
in these rules, Milords, there is.
Carriage permit, there is nothing, but how is the fare regulated?
Because I believe when the aggregators would argue, it would be in the similar manner as other taxis fare is. It depends on the market conditions. From state to state also it would vary.
These are the terms of the permit.
Yes, for Milords, an individual bike taxi operator in state of Punjab. And Lordship will see Rule 8 also on the next page, Milords, Condition 8, which deals with an aggregator. So, yes, owner shall be responsible for ensuring safety of women and children passenger. Motorcycle taxi permit shall be issued to new vehicles or a vehicle which is not more than 5 years old in date of registration. Because I say today, please put all these conditions to me or more. There is no difficulty that I am not saying please do not regulate me. But your inaction cannot mean that, Milords, my fundamental rights should be interfered with just because state does not want to take any action. Therefore, Milords, I say it's all in the vacuum. The single judge also, Milords, relies on it. Milords, with respect, that reliance is slightly misplaced. Milords, to say that till there is no regulation, please do not ply. Which means the regulations are to come, or there is scope for regulations to come, and that's when you should start plying. We are reading it, Milords, in fact, in an absolutely contrary manner, that no regulation means you cannot ply. It should have been, Milords, rather a duty or rather a direction to the state that within 6 weeks, 6 months or whatever time, please frame these regulations. And Milords, I speak for the association for the drivers. Absolutely no difficulty, whatever condition state wants to impose on us to ensure safety of passengers, to ensure that there is, Milords, ready data available. As Mr. Chinnappa said, if there are any individuals that the state does not want to permit to ply as drivers because of their criminal antecedents, etc., all of those measures can be taken. In fact, all of my data is available with the aggregators because I discussed with them. That data can today readily be made available to them because, of course, the state does not have any data. I have been given to understand 6 lakh bike taxis are registered in the state of Karnataka. We are looking at 6 lakh individuals plus their families, their livelihoods. As I started, Milords, by saying that some of these may own the bike if they have the means. Some of these would have taken loans, etc., to ply these bikes. In other cities, there are no other employment options also. Bangalore, one can still understand, Milords, that there can be some alternate arrangement that can be done in the interim. In others, second tier, third tier towns, this is for bike taxi drivers. This would simply mean that they will have absolutely no livelihood they have put their hard-earned money either to, my lords, obtain loans to get these vehicles. This is a real social problem. No, my lords, absolutely. But my lord, may imagine the people who are riding bikes as bike drivers. Because they, of course, come from a certain segment of the society. Now, my lords, just to take this forward, Lordship had that. My lords, next page, Lordship will see is a similar regulation of Chandigarh administration of the Union Territory.
From the locality, 3-month distance, it is 8 rupees per kilometer.
Who has decided it? Yes, just the next page, Lordship will see from Union Territory of Chandigarh also, my lords, the regulations of July 2019.
So this is in operation since how, when?
My lords, Punjab 2017, yes, and my lords, Chandigarh 2019.
It's in operation.
Yes. My lords, we'll see in 2019. Well, that data I'll come back to your lordship with, that how many, because these are two examples, because this question was posed by your lordships to lords Mr. Chinnappa as well as to the state, that whether any other states have these kind of regulations with respect to not aggregators but individuals, because otherwise, because the Motor Vehicles Act and lordship have seen the Karnataka motor vehicle rules also permit me to be registered as a contract carriage. Then where is the question of, my lord, state denying me the permission? My lords,
Now, we have seen the other
Just-
states also, the little states where this contract carriage or this bike taxi is permissible.
plus, I think Uber's petition has a list of 18 states.
Is there any stipulation regarding to the fare in the permit?
No, my lords. Because in fact, I was just instructed. Because I was just instructed.
We don't know, we have to examine whether the motorcycling, the transport authority can regulate a fare insofar as that is concerned as part of the permit, Mr. Raman.
But if the power is there, but if they choose to not regulate, it's a matter of how the market evolves.
That's right.
But sometimes in the initial stage, usually there is no need to regulate, because even the operators would want the computers to take their vehicles. Sometimes when it becomes more popular, then there is a tendency to fleece, etc. Then there could be a. There is under section 67, there are.
Except Bangalore.
Please. But of course, in Bangalore also.
Well, I've been given to understand that for bike taxis, it is 8 rupees per kilometer. But I've asked them that who's regulating.
That's the rule.
But
That is-
actually, they will fix it based on the consumption of petrol, the costs, the expenses involved, and not
Who will fix it? The
in
driver?
consumer. When we use aggregators, the aggregators will have a standard.
No, not an aggregator, individual taxi, individual bike.
Individual then naturally we go back to a situation where there are no aggregators.
Yes.
Perhaps the union, sometimes union would fix.
Yes. Lordship would recall the time when there were no Ubers and Olas, because the market conditions would prevail. The taxi driver can ask you.
Every taxi or the auto rickshaw, they have the meter.
Yes, yes.
But that meter is not.
Nobody goes by the meter. That's a common problem, Milos. In Delhi also, Milos, we have those meters.
100 rupees or 200 rupees for a fare which would happen.
Milos, in fact, there is a slightly strange problem that we have faced in Delhi, that passengers do not want to go by the meter because they think the meter has been tampered. They say, please give us a fixed price.
Here another problem. If you want to board here and come to Vijayasoda, he will go to MG Road and then come to Vijayasoda.
Because fortunately with Google Maps and all now, those problems are reducing. Yes.
Tomorrow, we'll go on Wednesday. We have tomorrow some matter. Have it on Wednesday.
Because I'm concluding, because I'm concluding right away, Milos. Yes, right away in 2 minutes, Milos, because I do not wish to take your lordship through whatever Mr. Chinnappa has said. That covers, Milos, what my case is. Milos, at the end, Milos, I am only saying that what are bike taxis doing in the system? What are they supposed to do? Milos? Contrary to what the state is placing before your lordship, it is to ease the traffic congestion. Everywhere, whenever public transport systems are encouraged, Milos, that eases the traffic congestion. People do not, Milos, then rely on their own cars and bikes and other vehicles. In fact, Milos, I was watching a YouTube video yesterday of a stand-up comedian, Milos. In context of Bangalore, he said now in Bangalore, cars have become immovable property because they do not move. So people can give reference of a car when they're guiding somebody. So we do not want that sort of a situation to continue. Because these e-bikes, as Lordship has seen by the state's own policy, are meant to connect the last miles. And in other cities, there are places where the cars and ambulances can also not go in. The e-bikes are providing those necessary services in those areas which are so remote otherwise that people cannot otherwise fly. They would be forced to walk for distances to catch a bus. So in today's situation scenario, these to my understanding, subject to what the aggregators in the state has to say, this is a necessity. It's not a luxury at all. We are talking about bike taxis. We are not talking about some luxury services here. Plus, in context of interim order, 4 years, it was. Very good.
Monday,
we have kept the other matter. It will not be possible. They say this. They say Mr. For whom you have been
for Bike Taxi Welfare Association, this is 74. Serial number 74, writ appeal 962.
Yes, my lords, in fact, my impediment is in the first writ appeal, in Mr. Dhyan Chinnappa's writ appeal. Very well. Very well. Yes, I'll do from the sense. Yes, it's the continuity because I'm for the commuter. Exactly. Yes, that was exactly why I wanted to point that.
Well, my one submission, with apologies, my application may be considered. End to end.
Yes, no, your application, you have served the other side?
Yes, my lord, I saw. Yeah, not everyone, my lord. Only Uber I have served. In the other petition, my lord, in four. But, much of this.
Number 63, my lord, is fresh matter, my lord, and this is the first day, my lord, because 63.
See, you were not there, then we adjourned it.
Got my lord, 2:30.
10:09.
My lord, matter is urgency, my lord, because
Who appeared for the respondents?
they are not, vote is not issued, my lord, VDA appears. Fresh matter, VDA, my lord. It's the case, my lord, where petition, the appellants are the successful. It's a short point, my lord. The petitioners are the, my lord, the appellants are the successful bidders of the site, my lord. After bid, my lord, the VDA received the fee.
You will give a date now.
Tomorrow or day after tomorrow, my lord.
14/7. 14/7.
14 July.
Because if the VDA put the site in public auction, my lord, then we are going to face the risk, my lord.
And for the caveated respondent number,
37.
my lords,
37.
my lords may make one submission, my lords.
SStv ಸಿನಿಮಾ ಜಗತ್ತಿನ ಕ್ಷಣ ಕ್ಷಣದ ಸುದ್ದಿಯೊಂದಿಗೆ